I'm Huw Thomas. I'm a partner at Carey Olsen in Jersey. I practice across a range of areas, most notably employment law and data protection, and a range of other areas which my partners politely or impolitely call the weird stuff. This is Carey Olsen's podcast, People, Behaviour and Governance, which is a podcast about people in workplaces, how they behave and how we should think about that behaviour. Today, we're welcoming one of our partners, Jeremy Lightfoot, who works in dispute resolution, what used to be called litigation before they rebadged it as something new and whizzy. Legal 500 Asia once described him as an excellent strategist with first-rate client handling skills, and rather more evocatively as an intellectual heavyweight whose urbane charm makes him a firm favourite with clients. Jeremy, welcome to the podcast.
Thank you. Good to be here.
It's always nice to speak to my partners, but the specific reason for asking Jeremy on today is the fact that he's recently relocated from Hong Kong to our Jersey office. And whilst this is still dispute resolution or litigation, they're two very different places, aren't they, Hong Kong and Jersey?
Yeah, I think there's probably more that separates them than they have in common. It's a remarkably different environment to turn up to.
So you've been a litigator for 20 years. So you were a barrister in London, and then you've been a lawyer in the BVI and then in Hong Kong. What took you offshore and then to Hong Kong?
It's like some of life's big decisions. I'm not entirely sure when it was made, but I do remember sitting in Gray's Inn. So I'd had 10 wonderful years at the bar in London. It's a fascinating job. But I blinked and 10 years had gone by. And I was concerned if I blinked another couple of times, then that would be my career. And I'd always wanted to live elsewhere. I'd always wanted to see different systems of law, different people, different approaches, different places. And if you want to do remarkable work in remarkable places, offshore was a really easy choice. So I applied for jobs all the way around the world. And BVI at that time was a standout for the level of work and the immediate impact I could have.
Huh. And has it been the same job in the four jurisdictions where you've worked? I mean, is a litigator, or is it very different?
I mean, fundamentally, yes. Fundamentally, you're still a problem solver, and you're always tasked with a difficult situation, finding the best, quickest, easiest solution, while someone on the other side is desperately trying to stop you. Now, that is in common between all the jurisdictions I've worked in. But I think there is a real difference, though, in the demands of clients. If you're in a court-facing jurisdiction, so something like the BVI, your job tends to look a little bit more like a traditional barrister's. If you're in more of a client-facing jurisdiction, such as I was in Hong Kong with listed companies and governance disputes and investment disputes in and out of the mainland, it tends to be much more immediate advisory and guidance, just as much as it is court work.
And are the clients very different in those jurisdictions, or there's some common themes? So.
Yeah. I mean, there's common themes. It's litigation. All clients want to win. They want to win quickly and want to win at a reasonable cost. I mean, of course, that unites them. But there's a vast difference. There's a difference in attitudes towards legal processes. There's different attitudes towards lawyers. Depending on where I practice, I'm everything from a trusted sage who comes in to pronounce, all the way through to an execution-only service provider who can't say no. And there's everything in between. So I think the character of the clients and what they want to achieve does really differ, depending on which jurisdictions you're in.
Which one was your favourite? Have you got a particular favourite, or are you...
I mean, the trusted sage who walks into court and pronounces. I mean, that's good fun. But
so everything you ever wanted to be, isn't it?
That's what I thought. Actually, the one I've really enjoyed the most is where you are thrown into a huge problem. So I'd be in mainland China. I'd be called into a boardroom and they'd say, "It's brilliant you're here. This has just happened," and throw some documents at me. And you'll sit there with the board, strategizing, working out all in real time, all really fast. Usually by the time you come up with your first strategy, there was another email. Someone else had served some more proceedings on you in another jurisdiction. And I mean, yeah, it's hard in the moment, but it's really satisfying. And you don't have that divide. I mean, when I started at the bar, my work came once a day wrapped in a pink ribbon.
From the DX.
Yeah, exactly. That was the idea of immediacy.
Yeah.
And that, fast forwarding all the way through to you're in a live board environment, the company's there with you and things are happening. I mean, that was really good fun.
And then you find yourself in Jersey, one of the Channel Islands. What brought you here?
Yeah, well, it's kind of a repeat. It's kind of the 10-year thing, because
Yeah.
after 10 years I went offshore, and now I'm coming to the end of my 10 years offshore. I was, as you mentioned, I was in British Virgin Islands. I was always destined for Hong Kong, but then Hurricanes Irma and Maria um, sped things up
Yeah.
considerably. And I was really happy in Asia, having a great time. I built a fantastic team out there, and we're doing some really good work. But then the option came up within Carey Olsen to move to Jersey, and I couldn't really resist the quality of work, the volume of work, where these islands are at the moment, and what's happening. I mean, it looked like the obvious and logical move, and I'm really pleased to say that it's turning out that way.
How are you finding it so far? Is it life in Jersey? Is it what you expected? Smaller place?
I'd love to meet someone in this situation who goes, I'm not really enjoying it. I don't think that's a legitimate answer. But no, actually, genuinely, it's been a real pleasure to arrive. I mean, I was vaguely familiar with the place. I understood the work. It's exactly as I hoped.
Yeah.
It is that blend of genuine market-leading cutting-edge work with a great lifestyle. So at the moment, I'm very much in the phase of what's not to like.
Are you missing anything about Hong Kong? Food or
I should probably answer my team first before I
that's a
go
good
on to
answer.
food. So
Yeah.
I think I should say, because they're bound to say, yeah, my team. It was great to work with them. I miss them dearly. Xiaolongbao, Hargao, in fact, just about any dim sum.
Yeah.
Actually,
It's not something we do in Jersey.
And please, if anyone says, aha, but I know where to get those in Jersey, please tell me, because I do miss that as a morning snack.
Yeah, fair enough. Are you bringing any elements of Hong Kong apart from the food to Jersey in terms of the work or?
I mean, there is some overlap between Jersey and Asia, and it's got real prospects and it's growing. And so I think there is in the future likely to be more overlap. Immediately, my experience, there hasn't been a huge number of contentious files that genuinely splay across Jersey and Asia. But I think it's more, how to put it, it's more the cross-border awareness and the jurisprudential awareness that is really interesting to bring to Jersey. And that probably needs some explanation. As with all the offshore jurisdictions, they tend to be forging new paths, finding new areas, dealing with new things that haven't been dealt with. Frequently, your life as a litigator offshore is encountering the new and finding a way through it, developing the law. And what I'm really finding is helping me enormously here in Jersey is because I've practiced in 4 other jurisdictions before. When we find one of those opportunities in Jersey law or practice, I've got 4 more reference points to think, well, how did we do it in the British Virgin Islands? How do we do it in the Cayman Islands? What was the law there? What was our approach there? And it's really good starting point for some solutions for here.
And what's the plan for your Jersey practice? You've obviously got a plan in place, but where do you see it going?
Yeah, there's a cunning plan. It's detailed,
Obviously.
the plan. The plan isn't exactly a state secret at this stage. It's not a sophisticated plan, and the plan really is get here, get busy, meet everyone, enjoy the work, see it develop. I'm really lucky to have joined a busy and diverse department that's doing a lot of what's available on the island, and my plan is just to get involved as much as I possibly can.
And do you think you'll continue any element of your sort of BVI Hong Kong practice, or is that going to sort of stay there, or are you going to bring anything across?
Some of it, yes. I mean, a lot of my clients had a word with me before I left and kind of checked that I was still prepared to take their work, and of course I am. Yeah. And so for these first couple of years, I'm applying to sit the Jersey law course, and so hopefully I'll be able to do that. And so in this transition period, I imagine I'll be doing slightly more of my Asia work whilst I'm also studying and learning. But we'll just see how it goes. But certainly, my disputes tend to be global by nature. The Jersey work is no exception to that. So I don't think it's going to be an isolated incident.
And do you think that your knowledge of the sort of Hong Kong and Chinese sort of market is going to be useful to the Jersey clients? Is that something you can bring to what we do?
To a point, yes. Although I think the market knowledge is pretty readily accessible. There's plenty of good briefing notes and institutions that can explain to you what's going on with the market. Actually, I think the real insights that will be helpful is how Chinese institutions and clients tend to operate internally, how to interact with them. It's a very different world, right through from how the relationships form, how the trust develops, how decisions are made internally, including decisions as to retaining lawyers or decisions as to authorizing litigation. That's really difficult. And I think I'll be able to help a little bit with that. And I'm certainly happy to guide kind of Jersey contacts through those situations when they find them, because they can be a little bemusing. I mean, if we've got time, I'll give you an example,
Go ahead.
because this was one that I was banging my head against the wall on this one. So the situation is, you have a large institution. It's had a business deal that's gone badly. Let's say it's lost 100 million. That was roughly the number in this case. They go for arbitration. They get a successful award. They win everything. And then they find 10 million of assets offshore. Now, if I was speaking to one of my New York clients at that point, it'd be a very short phone call. You've already won. There's 10 million over here. Do you want me to go and get it for you? My American clients would say, why are you still on the phone? So why haven't you already got it for me? But it took me 9 months to get that decision approved with a major Chinese client. 9 months in which that asset was at risk.
Yeah. And why was that?
There. Well, I ended up sitting down. So I spoke to some trusted contacts in Beijing to say, look, what can I do to sort this out? Then I spoke to the individuals involved and finally got to the bottom. It really comes down to the concept of personal accountability in major Chinese institutions, because it's different. It's very personal. So you have carriage in your role, typically, for the decisions that you make and nothing else. And not making a decision doesn't really count. So if your business has lost 100 million and you had no involvement, you're fine. But if you decide to authorize payment of lawyers' fees and, for example, it fails, then that is on you. And so there's a huge amount of care in the personal decision-making process.
That's interesting. And I can imagine that can be both a good thing and a bad thing. You sort of own your own decisions, but at the same time, it can take quite a long time to get to a collective sort of position.
I mean, yes, the thoroughness is great, and I applaud the attention to detail and the genuine gaming out all scenarios, including all the ways it can go wrong that we hope it won't. No, I completely understand that, but you've hit the nail on the head. It's the delay. Sometimes you just need to be nimble and fast.
Interesting. So, I mean, turning to dispute resolution or litigation, obviously there's a huge amount going on in the world at the moment, from the sort of war in Ukraine to sort of US tariffs to everything in between. Does that make it a good environment for litigators and dispute resolution lawyers?
Well,
good,
yes,
bad.
That's right. I was about to say, I mean, I struggle with the words, any use of good next to what you've just described. I mean, for some of us of a certain way of thinking, the current situations are depressing and seriously objectionable.
There's a lot to be depressed about. Yeah.
But putting that to one side, I mean, unfortunately, the answer is yes.
Yeah.
I mean, generally, disputes are provoked by change. So the market's rocketing, the market's crashing, all those things generally tend to provoke more disputes.
Volatility drives.
Volatility, precisely. So it has been a busy time for litigation, yes.
And what do you think we're likely to see in terms of litigation? Is it going to be like it was after the 2008 crisis, the types of fallout from that? Or is it going to be something different, do you think?
I mean, I'm not sure it's going to be quite the same. Some of the trends are similar. There are plenty of investment-based disputes, so failed investments particularly. Those will continue. There's plenty of corporate governance issues, a lot of shareholder remedies, a lot of boardroom fights. They're going to continue. The one that's difficult to quantify is actually insolvency and restructuring. There has been this surprising consequence so far that a lot of events that everyone predicted would cause huge volumes of insolvency and restructuring work still haven't really caused the volumes everyone was expecting. And so I think everyone commentating for, the last almost decade offshore has been saying we're expecting an uptick in insolvency and restructuring. Is that
because money's been cheap, or is it...
I mean, where I've been working, the money's been, there has been no money. There's been no access to some of the funds. It's been highly illiquid. Possibly, I think it's, again, I called out a few restructuring professionals on this because I said we're all starting to look a bit silly because we all keep saying there's a huge glass of work, and then every year we say there's more. And there is, I mean, I've seen more in my practice. So the last 18 months genuinely has been a lot more restructuring activity and a little bit of insolvency. I think possibly where we're going now is the logjam before is people didn't know what they were restructuring to. They knew they were in difficulty. They knew they wanted to get better arrangements, but they couldn't really call the future market to know how much they needed to do. People, whether they've now managed to work that out or whether it's just been so long they have to pull the trigger, I'm not sure. But a lot more people are pulling the trigger. So I think we will see more restructuring mandates over this year.
And is Jersey in a good place for that sort of litigation? Is it a good forum?
There's an awful lot of options for restructuring Jersey. I know there's discussions about adding some more statutory tools. It would be great to see those, but there's a lot of people mentioning it, and hopefully, I would love to see that come to fruition.
And in terms of what we need from litigators, the sort of skill sets and that sort of thing, does a time of volatility require something different, or is it more of the same, or is it?
Essentially, they're the same disputes, but they do appear in a slightly different context. So you're right to ask the question. I think the key one really, it's speed and cost. That's what's different.
Agility.
Agility. The times when you could sit back and come up with a lovely strategy, spend 6 months, backing around with the clients and working it out and costing it all out. I mean, the volatility doesn't really allow you for that. But also we have to be conscious, and it's not just speed, it's cost, because a lot of our clients are in a position where, all sorts of spending is restricted and carefully monitored, and legal spend is certainly not an exception to that. So the value of actions. Previously, if you had, let's go back in 5 years, if a company found that it had been, had an actionable wrong and be done to it, it would, often the presumption would be, yes, let's go fight, let's sort it out. Whereas now it's much more of a value proposition. People say, well, yes, great, we have that claim, yes, we'd win, but what would it mean? What would be the outcome? Where are we actually trying to get? Is there a cheaper way of getting somewhere similar?
Yeah. I mean, this is a podcast about behaviour. And of course, we now live in a world where with more volatility becomes less predictability. And of course, as a result of behaviours, often amongst sort of government figures, things are significantly less predictable. Do you think that's changed how clients think about risk, or how they should think about risk, and then litigation risk? I mean, are they more sophisticated? Do they understand enough about litigation risk in the main, or is it still something that the clients struggle with?
I don't just think it's the clients. I think we as lawyers, we all struggle with how to analyze and quantify the risks.
Yeah.
And I think that depends on the character of the client, it depends on the character of the lawyers, and it depends on the severity of the outcomes. I mean, the idea that you can simply put a percentage figure is seductive. It appears to be creating certainty in an uncertain situation, but it's rarely representative.
Yeah.
And we found the best thing that most of our clients, to really help them to understand and appreciate risk, it's not the percentage success of what you're trying to achieve. That is only one factor. It's the severity of the other possible outcomes and what they would mean for you and what would happen in those situations.
Worst case scenarios, yeah.
The worst case and the second worst case and the third worst case. And that's the thing, you need the full picture, because if you are, for some boards, if you're running even a small risk of a catastrophic outcome, that's not an acceptable strategy. For other boards, they are happy to take a robust approach and pursue what appears to be, the most likely positive strategy, and deal with the adverse outcomes if they come.
And the difficulty with people's behaviour, and particularly when it comes to litigation, I always think in my own field in employment is the fact that we tend to react emotively to situations, particularly employment disputes, and people's views and emotions tend to change throughout a dispute because everybody's really angry at the start. Nobody wants to settle. Give it 6 months and cost, and all of a sudden everybody's sort of taking a very different view. And part of the art for, say, employment lawyers is trying to encourage that level of emotional change just very rapidly, so we can get to a proper and well-reasoned decision more quickly than it otherwise would. Yeah. I mean, do you find that in general litigation that people's emotions get in the way of?
It may not, the facts may not look as personal as, say, an employment or a family dispute, but they're often taken as personally, and the emotions can run very high. And absolutely, I mean, the emotions can be very helpful because often you can unpick what is causing that emotional reaction, and that usually is the shortcut to finding what the most important problem is to be resolved. The management of the characters on all sides is tough, but I agree entirely. If you want to see kind of the full spectrum of human emotion, sit through a day of mediation.
Yes, well,
Because
definitely.
you can absolutely start
Yeah.
with everybody grandstanding, sneering as people come in the room, real animosity, and you can go through everything towards the end with everyone clapping each other on the back and a handshake and leaving out in a position where no one could believe that they could possibly have got to that spot.
Yeah, and sort of mediation, I always thought it's a shame that more people don't go for it in a either at all or in a more constructive way, because when it works, it can be almost magical in terms of the most intractable disputes being solved.
Mm.
It's extraordinary. Do you think we do enough in relation to sort of ADR and arbitration and mediation and encouraging it? I know courts are very keen on it, but it's
Yeah, I mean, I I think in my practice, I think we do. I mean, arbitration isn't. You can choose to arbitrate ad hoc, but typically arbitration is baked into the documents. So it's not really a choice. Normally, it's arbitration or court, and you've
Yeah.
already
And a
pre-decided.
lot of arbitrators look very court-like these days as well. I mean, it's
They
a sort
do,
of very similar process.
and they can cost even more.
Yeah.
So.
Not ideal. Yeah.
not how the system was born. And that's a generalization. Of course, there can be cheap and efficient arbitrations.
Obviously.
Mediation, I think, is the interesting one, because I agree with you. There is a school of thought that says some disputes are not suitable for mediation. I've never quite understood why. I don't really understand what would make a dispute unsuitable for mediation.
Because if you're going to settle it, you can probably do it in a mediation.
Exactly.
I mean,
Exactly. But I do agree there is a time and a place for mediation. When people, for example, when they've just filed their court proceedings, it would be a very rare case where that would be the moment where you could get everyone round the table and get a
everybody's
solution.
quite angry.
Sometimes, but
Yeah.
no. But I think at the right point in a case, I think it's important it's tried. It doesn't have to be formal. It doesn't have to be with an approved mediator in a conference room in somewhere. It can be informal, whatever really suits the people involved. But I think it's a really important option, and typically I find it is actually attempted in most cases.
Yeah. I often think it requires a lot of lawyers to put their egos aside. And
We don't have egos.
no, obviously not. No, but but being able to say to others, look, we could be very confrontational, but actually being slightly less confrontational, engaging in mediation could be the way forward here. That's a big step for clients. I often think it's a big step for lawyers as well.
I mean, you're right. You're right, but also it can be a refreshing opportunity, because particularly with, say, a large institution, you've got diverse decision makers. It'd be a sprawling dispute going for a long time. Actually, it can be really refreshing to have the opportunity to get the decision makers in the room with you. Everyone's focused on it. For that day, we all put away our other requirements and commitments and just focus on trying to untie this knotty problem. Yeah. It can actually be a great opportunity for the lawyers and the clients as well.
And it's always amazing to me how many incredibly complex and sprawling disputes actually, when it comes right down to it, come down to a very narrow range of points. And I always think that mediation can be really, really useful in even if it's unsuccessful on the day, actually working out what the points of issue are, because most disputes, as I say, seem to come down to a far narrower range of issues than we ever think.
Could I gloss that slightly
from
my perspective? I know what you mean.
Yeah.
I know what you mean. But as on kind of my litigation side, we generally think we've got to the bottom of what the issues are. We really should be able to. That's our job. But what I find it exposes is not so much just what the issues are in the case, but what the issues are to settlement. And the two
different things
can be quite different. And it can only be after a long day of mediation that you suddenly click and think, this is what the problem is.
Yeah. That's where everybody's coming from.
We need to solve that with a completely different strategy. And that's why mediation is great, because of course you can typically agree anything in mediation, whether or not the court could have ordered on your dispute. So particularly if it's two warring businesses, if there's that one other thing in the way, they can reach a separate commercial deal on that aspect in order to facilitate the underlying settlement.
Yeah. And in a changing industry, is what we need from our people, as in people we recruit and develop at Carey Olsen, changing as a result of change in the industry and the way things are changing?
I think it always has been changing. I think the role of the lawyer, and certainly the litigation lawyer, has developed considerably. It's possibly the pace at which it's changing is the real difference now. Yes. Straight answer, yes. The needs of our people are changing, and changing fast.
Yeah. And on the flip side, of course, what people want and expect from work is changing. So we talk about a lot about Gen Z, Gen Z, and their wants from work. And of course, there's at least a perception that younger workers don't want to work the long hours that were previously sort of regarded as non-negotiable. Is that something you see in practice?
Yeah, I mean, I come to the school of thought. I don't actually think that's fair on Gen Z.
I agree.
I think there is that view floating around, and it is easy to look at some evidence around an office and decide that's correct.
Yeah.
My personal experience of managing Gen Z is actually they can be phenomenally dedicated and hardworking. The difference is they have slightly, again, this is grossly generalizing because it has to be, because we're talking about an entire generation. There tends to be more of an emphasis on understanding the why.
Yeah.
If they're told to kind of sit through the night photocopying and bundling when it could be done by a computer program, you will find it extremely difficult to make someone do it. If it's
and they'll have a point.
And they'll have a very good point. If it's a sophisticated point of law and it's an emergency injunction the following morning, I would never doubt a Gen Z to stay up all night and do everything that was necessary. So I think it's more of that, because it comes down to what they want out of their careers. And again, sorry if we go slightly off topic,
Absolutely.
but just to give you an example, because I always find if you just talk about your own opinions and ideas, it's great, but sometimes actually just examples let people draw their own conclusions. So things you've seen happen. Certainly with my team in Hong Kong, the reality is if there was a choice between A, a larger bonus, or B, being the lead associate on a brilliant market-leading new case that we've just landed, people would choose B.
That's interesting.
Now, from my generation, that way of rephrasing that choice is you want to do more work for less money.
Yes.
And so there's a very different concept of value out of the job. The job is experience, skills, development, exposure, prestige, future prospects. That is just as important, if not occasionally more important, than the paycheck.
That's a more sophisticated way of looking at it, isn't it? Rather than the immediate. That is interesting, actually. I mean, it's something that we see, I think, in employment lawyers, that the skills and aptitudes are changing so rapidly because the nature of our clients are changing so rapidly, and actually there are no stereotypes when it comes to any generation, but particularly Gen Z, that they are as varied as you'd expect and hope, and actually sort of bringing out those sort of slightly lazy stereotypes is quite difficult.
Yeah, and I mean, and like it or not, that they are the workforce coming through. So it's our jobs to get the best out of them, and there's an exceptional amount of talent there. Absolutely. If we can work out how to harness it.
Yes, and of course we're older and don't understand them, and all of the above. I mean, the other thing, of course, that's driving huge change, and we're probably just at the top of the mountain at the moment, just about to sort of career off the other side, is the use of artificial intelligence, AI. I mean, litigation has been something of an early adopter in AI, hasn't it, in terms of things like e-discovery. But seemingly now we can't move for AI and its potential uses. I mean, you're obviously very much on the front line of this stuff. What are you seeing in terms of where it's going?
We're already falling off the far side of the mountain.
Yes, good to hear.
Absolutely. I mean, AI is, it's probably not an exaggeration to say it is in use to some level in every aspect of litigation. Yeah. And so there is a sliding scale from basic document processing, things that actually automation tools could probably have done pretty well,
and we should have been doing already.
And then it escalates through to summarization type things. Then it escalates to research, preliminary drafting, preliminary advices, and then it goes all the way through to the kind of the nuanced judgment calls of how do I phrase a question in cross-examination, or what should be that last point that I leave in the judge's mind. Now, on that spectrum of litigation, people will be using it for every stage already. The reliability obviously differs on where you are on the spectrum, and who chooses to use it at the moment on different parts differs, but it's in use everywhere. And we will see that continue to accelerate because the economics of it are so attractive.
Yeah, absolutely. And we've seen the sort of couple of horror stories recently about sort of lawyers and barristers, particularly junior barristers and lawyers, using them to sort of generate courtroom submissions, which with fictitious sort of case authorities. But the interesting thing there is not for me the misconduct element or the contempt element or the fact it's getting it wrong. It's the fact that people are trying to use it for those things in the first place. It's only going to get better. And we're probably going to reach a stage pretty rapidly where the errors get fixed. And what we will increasingly see are people using it for submissions about cases to courts, which is going to transform things.
I agree with your outcome,
Yeah.
definitely. I think it would be
probably a long road.
It would be difficult to say that it won't transform legal practice. I'm one of the people who believes it will. Will we get to the stage of the technology where hallucinations are no longer a problem? My understanding of the technology is unlikely.
Yeah.
So
no time soon, anyway.
There is always going to be the need for the check or the review, but it's a sliding scale, isn't it? Because rewind 10 years, 0% could be done by AI. Where are we now? We would differ, but it's a high-ish number
and increasing.
Will it go high? Yes,
yeah,
absolutely.
Do you think it will change what clients are asking of us in terms of being litigators and advisors?
I'm not sure it will change the outcome, the end product. At the end of the day, litigation, as I said, clients want us to solve a problem cheaply, efficiently, and get to the outcome. That stays the same. It will change, and is changing, clients' tolerances for how that is done. And so if I said to clients, I want to set a team of 4 people on researching the law for a month, in 20 jurisdictions.
Oh, the good old days. Yeah.
And they are perfectly well aware. Let's go forward a couple of years. So some of the case databases are a little better than they are now. That could be done in 5 minutes with some suitable prompts.
Yeah.
There will be zero tolerance for that level of, frankly, indulgence.
Yeah.
But it's still the strategic nuances of how to get there. I would like to think will be the last thing to go if they go at all. But we're going to have to keep this under review, because if you'd have spoken to me 10 years ago, every answer I gave on this topic would be wrong.
Yeah, absolutely. Yeah. And I think the art of research is going to change, isn't it? That it's knowing where the gaps are in what the AI engine is telling you. It's knowing what might not be written down or might be in paper form somewhere or whatever it might be, particularly in a place like Jersey. So.
And I think that's the exciting bit for the litigations, because people think of the threat. I'm seeing the excitement, because previously, if your dispute was $1 billion, then you could proportionately look at comparative law from, as I say, many Commonwealth jurisdictions, dig back into the 19th century, look all over the place. It's worth it. If your dispute is $10,000, it never was.
No chance. Yeah.
Well, what AI would allow you to do now is, even on the $10,000 case, yes, it's proportionate to have a look, and you might have a better answer. You might have a better argument. And of course, you have to be super careful to check the outcome.
Yeah.
But it will be potentially a shortcut to making even smaller disputes more sophisticated and more precise.
And in terms of what it does to the legal industry, does it mean that much smaller firms are able to sort of go toe-to-toe in litigation with much larger firms? Does it give them an element of scalability that they possibly didn't have before?
Potentially, yes. And I know some people have been publicizing their efforts. People have literally been saying, I'm this small firm with 3 associates. I've gone against insert name of major American law firm here. I'm not actually sure that's quite right. I don't quite subscribe to that, because I've done many of these kind of multi-billion-dollar shareholder disputes, for example. I did a $45 billion shareholder dispute.
Yeah.
We had a team of 4 people, and that was normal.
Yeah.
The concept that these enormous cases must have 40, 50 people and that needs AI bots all over the way, it's not actually right. Some of the biggest cases are done by really small, tight, focused teams, and that is how to efficiently run the case.
Yeah, you might buy in e-discovery or whatever it might be.
But exactly, and you're absolutely right. That is where the point becomes true, though, is that absolutely, in the old days of doing a document review, that would have taken a team of 50 or so. And now there would not necessarily be any limitation to doing that with a much smaller team with the standard tools backing it up.
Yeah. And if AI is going to replace an awful lot of these more basic tasks, the research tasks, the drafting tasks, the document review stuff, what does it mean for trainees and junior lawyers? How do we develop the senior lawyers and partners of the future if they're not going through those more basic tasks?
Yeah, we need a Gen Zer in the room. because what's going to happen is you and I are going to say, that is how you learn to be a lawyer. That's how we learn. Look how well we did.
Yes, all those good habits we acquired.
We learned by diffusion. My time photocopying and you remember manual paginators?
I do,
where
yes.
they flick over. You click and it automatically goes on to the next number. That was great. The idea that the reason that we say we're good lawyers now is because we did manual pagination at 3 a.m.
Yeah, it's exaggerated, and untrue. And,
it is. I think, but there is a slightly more serious point in it. Is that I think for a long time, law firms have relied on the practice of tasks that juniors have to do as being their training. Those tasks are disappearing, and now that is being exposed for what it probably always was, which was not quite good enough as a training plan. Paginating at 3 a.m. doesn't really teach you a lot.
No.
And I think that if it increases the need to have a slightly more professionalized training plan of really, as you say, looking for what skills do people actually need to develop to be a lawyer of today. I think that's only a good thing.
Being able to develop AI prompts, is a skill that almost nobody has, certainly in most law firms. I mean,
it's a really big skill. I think we're going to have to look at our training models, but of course, then we have to look at our pricing models, because that's the flip side of it. Is previously the training was all payable work.
Yes. Yeah, and maybe it won't be anymore. A lot of thought needs to go into it. Certainly going to be very interesting. Is it something that excites you? The future of litigation? I mean, it's a sort of like grandiose question, I guess, but with a very serious sort of undercurrent, which is, are you happy still to practice in a world that's going to be dominated by AI, or is it?
Absolutely, yes. Yeah. Because for me, I don't see the cost cutting and the efficiency and the hallucinations and the problems. They all exist.
Yeah.
But what I see is the ability to go further and deeper and more thorough and do that in an efficient way that is sensible for the clients. Yeah. We can fight these cases at a much higher level now for a much lower cost. And that gives you an edge.
I mean, the interesting question for me is are we going to see things like AI judges? So if something's done on the papers, like an arbitration or something like that, are we going to see AI dispute resolution in future? And the answer is very possibly.
Well, that would be a genuine game changer.
Yeah.
Because the one bit at the moment that informs most litigation is, in the end, the idea that a human will make a decision. Yeah. And most of our strategies and tactics eventually come down to how to persuade that human.
Yeah.
The concept of persuading an AI judge is a misnomer.
Yes.
We will have to reverse engineer how to get the outcome. Yeah. And that is going to be a very different art form.
But if you ask clients, would you rather spend 5 years and millions of pounds to reach an outcome with a human judge, or we can go to an AI arbitrator in an afternoon and it will cost a lot less? We might lose, but it will cost a lot less. A lot of them might say, actually, well, we might take our chances with the machine. I don't know.
It's possible. It's possible, and it's more likely to be the case for, say, a carriage of goods or a shipping thing where there's a delta between the positions of the quality of the cargo. It should have been what we think it should have been worth $1,000 a ton. They say it's only worth $650 a ton. Yeah. That kind of sophisticated commercial parties, would they rather essentially have a coin toss or an automated process? Say they shove some information in and they'll live with the answer because it's cheap, quick, and get on with their business. Absolutely, yes. But if you put it into the world of, say, a contentious governance dispute that controls the future of a family business.
Yes, which is reliant on the state of knowledge of people at the time making decisions.
Exactly, and is highly personal and means more than just the dollar value. I think I struggle with the proposition that the warring camps in those types of situations would be comfortable essentially doing the quick and dirty, unreasoned, just have an AI program decide it. I don't think that would be lead to an outcome that people will really be able to prepare to accept as a just determination of their dispute.
Unlikely to be any credibility behind it. I think it's probably the answer. Be very interesting though, and whatever comes beyond Gen Z, I guess we'll find all of this out. But
and we know we're going to be wrong with everything we said
almost
on AI.
Certainly,
yes, that's the only guarantee. Yes.
So I'd like to thank Jeremy for coming in to talk to us. Thanks, Jeremy.
You're very welcome. Pleasure to be here.
Good. If you'd like to talk to Carey Olsen about any of the issues we've covered, please do get in touch. Or if you've got any ideas about future topics, please do let us know. In particular, if you'd like to speak to Jeremy about his experiences in Hong Kong and China and how he might be able to sort of help your business, do get in touch with him. Otherwise, we will see you next time.